All right, welcome everybody. Good to see you. Or as they say, it's better to be seen than viewed. I miss not seeing you live and in person. And for those of you who are out there live, thank you for joining us again. It's a beautiful day here in Frankenmuth, it's approaching 70, and there's a lot of neat things for you to be doing outside. So I'm glad you're joining us. But as Pam said, she's now recording these and posting them. So if you miss a session and want to hear it, it's now available. You just check off or go to the website for the library, and they're all recorded there, and click and away you go. Okay, what we're talking about tonight is some legal concepts. Last week, we were talking about what I call the constitutional architecture. And if any of you have missed that, I'm going to do a brief review so we can talk about that. But now we're going to talk about things such as judicial review, the rule of law, stare decisis, and some other legal concepts. And the reason why is we're going to be discussing those when we get into specific cases. So this gives you a foundation. And last week's class, that was a lot on how we got our Constitution and how it's structured. And this week's class on basic constitutional or legal concepts. Both of these together form our foundation so that we then can go forward with our study of specific kinds of cases. And we're going to be getting into several of them. Next week, we're going to be talking about the 14th Amendment. So I like to look at the Constitution initially as drafted, as I said, how we got it, its architecture, and then the Civil War had such a profound impact upon our country and our Constitution. Indeed, how we relate to the federal government and how the federal government related to the states. And that changes that delicate relationship of the dual sovereigns. So we'll be getting to that next week. And then the week after that, we're going to be getting into a number of cases. And with your background then of the architecture, the background in legal concepts, and then the 14th Amendment, ideas of equal protection and liberty and due process, then we can go forward. Now, you're hearing a lot from me, and that's because I'm filling the gap. And the gap is because the Supreme Court really isn't issuing a lot. There is a case we're going to talk about tonight that came down, and it's going to be about standing and mootness. So we will have that, but it's not a big case. I wouldn't otherwise bring it up, except it highlights some of the concepts we're talking about. And I'm still waiting for two big First Amendment cases, one on freedom of speech and one on freedom of religion. So that's what I'm waiting for. And my fear is if the Supreme Court doesn't start moving, they may not announce those decisions until we've adjourned at the end of June. Well, that's what we've got going. So let's take a brief review. And here is something that I just saw in the New York Times this week. And this is actually going back now 2 weeks, where we went into that long discussion of a nation divided. And this was an article called Social Media and Psychological Forces Encouraging the Sharing of Disinformation. You may recall that we were talking about how 70%, according to an MIT study, showed that 70% of false tweets are recirculated. So we tend to circulate on social media false stories, not true stories. And why is that? Well, here is a story about that. Just a brief clip. As much as we'd like to think of ourselves as rational beings who put truth-seeking above all else, we are social animals, wired for survival. In times of perceived conflict or social change, we seek security in groups. And that makes us eager to consume information, true or not, that lets us see the world as a conflict, putting our righteous in-group against a nefarious out-group. I want to pause there for a minute because that is coming right out of the book that I promote so often, The Righteous Mind by Jonathan Haidt, Why Good People Are Divided by Politics and Religion. This is essentially what he's saying is we're hardwired, we're essentially social animals, and we have emotional reactions to things. And then we engage in what he calls a post hoc or after the fact rationalization of a decision that we came to intuitively. The article goes on, and social media, which is a powerful outlet for composers of disinformation, is a pervasive vector for misinformation itself and a multiplier of the other risk factors. The problem is that when we encounter opposing views in the age and context of social media, it's not like reading them in a newspaper while sitting alone. It's like hearing them from the opposing team while sitting with our fellow fans in a football stadium. Online, we're connected with our communities and we seek approval from our like-minded peers. We bond with our team by yelling at the fans of the other one, and belonging is stronger than facts. So that's kind of scary, but that is that insular, what some folks say, that we are in a silo when we get on social media, because we surround ourselves with people who agree with us and bombard us, and we're not really searching for the truth. We're trying to be comforted because frankly, we all feel somewhat threatened by what's going on. And this is irrespective of political point of view. It's everyone is reacting that way. Okay, review. Who created the federal government? This to me is a fundamental question, because I want you to think beyond just the fact that we have states and that exist. We have a federal government and they're the big dog, and states are just geographical designations and they're the little dog. That's not how we got started. We got started by the states who formed the federal government because of the failure of a loose association. So we were at 2 points in our history most at risk of splitting up into multiple states, multiple countries. And that was after the Revolutionary War, after we were no longer part of England. There were forces that could have said, well, we're going to go our own way. You go your way and good luck and God bless you. And similarly, during the Civil War, that's exactly what happened. The South seceded and said, we're done with this union. It's not working for us. We're going to go our own way. But in both of those times, through the Constitution, we were able to stay together. Unfortunately, the Civil War took a war, but then we're going to see through the 13th, 14th, and 15th Amendments how those amendments to the Constitution strengthen us, and as Lincoln said, gave us a new birth of freedom. We talked about federalism, the relationship of sovereignty of the individual states and the sovereignty of the United States, or the states united. And it's a delicate balance. Constitutional architecture, sovereignty, what is that? That's the ultimate authority. This week, the Queen opened the Parliament. And normally she is there with her ermine robes and this great big crown representing the sovereign. She didn't do that this time, a break from tradition. But she is the ultimate authority in times when kings and queens were supreme. Their word was law. Well, with us, we decided, no, we, the people, are going to be sovereign. And we expressed that through the states, the individual states, and then through the states collectively informing the United States. Structure, we looked at our basic three branches, the Congress, the executive, and the judiciary, the components. In the Constitution, we've got the original text that lays out the three branches. It also has provisions in the original text for what I call government process, how government works, how votes should be taken, how it's to be organized. Governmental powers are separated so that there are three separate and co-equal branches of government. And then this is, I think, a reaction to the Articles of Confederation. There actually is a supremacy clause that the federal government has, that it trumps the states. That is to say, we want everyone who is in the federal government to take an oath, everyone that's in the state government to take an oath to support the Constitution, because we are all under that. But if there is a point of rub between the federal government and the state government, the supremacy clause usually trumps that. Then we have the amendments. Now, these are important. The first was the Bill of Rights, 1789 to 91. It was so important because it needed to be, we needed these amendments right away, in order to get the Constitution ratified. It had to be ratified by 9 states, and there was that wasn't a foregone conclusion. Frankly, the delegates to the convention from New York walked out, and Governor Clinton of New York wasn't too excited about a federal government because he viewed it that if there's going to be a federal government, my power as governor of the great state of New York will be diminished. So he wasn't willing to surrender that. Virginia was not eager to have a federal government. There were very significant political players in Virginia, such as Patrick Henry, James Monroe, future president, who were not eager to be part of a federal government. They wanted to have the supremacy of Virginia. And if those two states had not ratified the Constitution, that would have been a big mess because look where they are. You'd have had New York, a separate country, and yet the New England states, Vermont and Massachusetts and New Hampshire, would have been separated from the southern states because of the position of New York. The southern states like Georgia, South Carolina, North Carolina would be separated from the north because there's Virginia, and Virginia would be a separate state. So we needed to get everybody on board, and eventually that occurred. But it was because of the Bill of Rights. And the reason why is a lot of people looked at those structures of the original text of the Constitution, and they didn't see enough rights and protections, both personal and collective. And by collective, I'm now talking about the 9th and 10th. Initially, that supremacy clause may have scared some folks because they did not want this big looming federal government that was going to tell them what to do. So the 9th and 10th Amendments simply says, and I'm paraphrasing from both, the powers not delegated to the United States by the Constitution are reserved to the states respectively, or to the people. And what that clearly indicates is that, again, the power comes from the states and from the people through the states. And the government that's being created is a government of limited powers, limited authority, because if you don't see it in the Constitution, powers not delegated to the United States in the Constitution are reserved by the states or to the people. All right. The reconstructive amendments, those are also important. We just mentioned those. They finally addressed slavery. Slavery had been the unspoken issue. And when I say unspoken, slavery is not mentioned in the original Constitution, comes up in the 13th where it's outlawed. But before that, it is not there at all. And it was just kind of overlooked, but it was a big problem. And then we move on from that to civil rights and working towards a more perfect union or a birth of freedom. The Congress, bicameral, House and Senate, the mere structure of our Congress is an expression of the resolution and compromise that was huge at the time of our forming our Constitution. And that is, who should rule? The people by population, or the states, because they're the ones who are creating this, by virtue of being a state. And obviously the little states, that is to say, Vermont, New Hampshire, Rhode Island, Delaware, weren't too excited about going through the population route because they were going to be overridden by the big states, New York, Pennsylvania, Virginia. So this was the compromise. The House would be based on population, elected directly by the people every 2 years. And tax bills would originate in the House, so that any tax would have to have the imprimatur of the people desiring it. The Senate, on the other hand, every state gets 2 senators, regardless of size. And so we then have a balance. And then when we elect the president, it's the Electoral College is a mirror image of that compromise. These entities, the House and the Senate, share duties and responsibilities. The executive, of course, is now to faithfully execute the laws. The idea was that Congress would pass the laws. The president would just be there to discharge. The president is elected by Electoral College for 4 years, minimum age 35, makes appointments with the advice and consent of the Senate. So there's a sharing there. Commander-in-Chief of the Armed Forces, but Congress itself declares wars and then powers to grant reprieves and pardons for offenses against the United States. And then in my view, almost as an afterthought, they get to the judiciary. So Article 1 was the big one. How are we going to rule ourselves? We've thrown off the king. The Articles of Confederation don't work. We have to come together. What are we going to do? How are we going to do that? And that's how they came to the Congress, and what I just explained, the House and the Senate. And the president, we don't want a king, even though Hamilton, excuse me, Hamilton wanted the president to be elected and serve for life. Most folks said, no, we don't want that. There's no limitation on the number of times someone can be president until there was a constitutional amendment in the 20th century that changed it. But we don't want a king. So they argued about that. And then it finally comes to the judiciary. And that was, as I said, kind of almost a secondary thought, is why do we even need it? We've got our own state judges. And they said, well, we need it because there may be a conflict between our states. So they said, okay, here's what we'll do. The judicial power of the United States shall be vested in one Supreme Court. There you go. And then such inferior courts as Congress can ordain and establish. So they punted to the new Congress to decide, you need to figure out whether we need a federal district court and a federal court of appeals. Congress did with the Judiciary Act of, I think it was 1797, I think. And from there on, we now have the judiciary growing, but it was not by design to be as powerful as it's become. It's the shortest article, no mention of the size. We are debating again how large the Supreme Court should be. No mention of the qualifications, as I showed earlier, about age or education. It's not geographically based, so it's not supposed to be representative of the people. No statement creating judicial supremacy. We will be getting in that tonight. And it didn't even have a permanent home for 146 years. Met in various rooms in the Capitol and even a private home until 1935. And we show where Alexander Hamilton said that the judiciary, by comparison, is the weakest of the three departments. And we have nothing to fear so long as it does not join those other departments. All right, that's our review. Before we get started with tonight's program, does anyone at this point have any questions or comments? Maybe something that came up since we met last about what I call the architecture of our Constitution.
Chris, do you want me to go over some of the questions in the chat?
Yes.
Okay. So one question is, are we at some time going to talk about the cases the court decided not to take up? Example, the federal interference in the way states handle elections and election fraud.
The answer to that one is no. And the reason is we don't know why. When the Supreme Court grants what's called certiorari, which is the fancy word for them simply saying, we will take that case up. They don't have to take cases up. They can choose to decide or not. It takes 4 votes. There's 9 members on the Supreme Court. If 4 justices vote to grant cert, they will then take the case up. So as I indicated, that they've already taken votes that next term, beginning October 1st of this fall, they're going to take up a Second Amendment case, which tells us that 4 justices said yes. We don't know how many said no. Maybe 9 said yes, maybe just 4. We don't know who. They just announced that they will take it up. So you really can't analyze if the Supreme Court decides that they're not going to take one up. They don't explain the decision. Now, sometimes, it's very rare, but it has occurred. In fact, it's occurred this past term. Some of the justices will dissent when a case is not taken up. And I quoted from a dissent of an order, it's not an opinion, where the Supreme Court did not take up a case. If you remember, it was the case where Texas was suing California, or maybe it's reversed, California versus Texas. And Justice Alito, in a dissent, said he thinks this case should be heard, but the Supreme Court didn't explain their decision. So we have absolutely no idea why they didn't take it up. All we know is because Justice Alito and Justice Thomas disagreed. They think the case should have been heard and wrote an opinion or an order on that. Any other thoughts or comments?
Yep. So another question was one I talked to you about before, and it's, can you talk about the Convention of States? The application has been introduced in the Michigan House recently, as it has been in 40 other 48 other states. 15 states have passed it so far. Could we be on the way to exercising our power as written in Article 5 of the Constitution?
Article 5 deals with amendments, and one of the ways you can amend the Constitution is by holding another constitutional convention. And the way they can do that is, again, pop quiz, who created the federal government? The states. So the states can call for another constitutional convention. They did it, and that's how we got this one. They can do it again. It does take 2/3 of the states, or with our current 50, takes at least 34 states to agree. It has never been done before. We did it once with the Articles of Confederation, but since that time, it's never been invoked. The way we've amended the Constitution is through a specific amendment passed through Congress, then submitted to the states ratified, it becomes part of our Constitution. There are some issues, and we don't know the answers. The first issue is, a lot of times a state will vote to call for a constitutional convention for one issue, for one concern. And it might be, we want a balanced budget amendment. Okay, they may call for a constitutional convention because they want to have a pro-life amendment or any single issue. Well, the question is that all the constitutional convention can address? Or once the states are gathered in this convention, can they go and consider other things? I don't know. If you remember when we did the revisions to the Articles of Confederation, we came out with a whole new document called the Constitution. So I don't know if you can bind and limit what a convention could hold. But there are, I did a quick research on this. So far, there are 42 states that have at least one Article 5 resolution pending. They haven't passed it yet, but it's pending. So it could happen. We are close. There's, as I said, a federal balanced budget has gathered 28 of the 34 needed. There is one that wants to reverse Citizens United, which is a Supreme Court case dealing with freedom of speech and the ability of corporations and unions to make contributions to political campaigns. 5 states have called for a convention on that issue. 12 states have called for limiting federal government's powers, restraining fiscal spending, and congressional term limits. So that's out there. That's got 12, but nobody yet has gotten 34. We're getting close, so it could happen. Here's another question. If a state called for a constitutional convention in the past, could it rescind its vote? And I guess the answer would be yes. And the reason why I say that is that one that dealt with a balanced budget amendment, I believe Indiana was the first one calling for a national constitutional convention on that question. And they did that in 1957. So maybe the good people of Indiana have a different view now, and maybe they may not say it, or some of the other states that have voted for it. So where we are now is it's possible. We're getting close, but it hasn't occurred yet. And again, we don't know how limited such a convention might be. All right, any other questions?
There's one that says, was FDR the last to try to pack the court?
Yes. Yes, he was the last.
And that is it.
Okay. Thank you for those comments. All right, I'm going to back up here just a little bit. Last session, we had a lot of pop quizzes. We're not going to have that many. We're going to have some pop quizzes this time. I'm switching a little bit to essay questions. And no, you're not going to have to write anything. But I want you to think, and that's the whole point of the pop quizzes, and that's the point of this. I want you to think about the question, and then we'll move on. So the first question is, not really a pop quiz, is what is the difference between the Declaration of Independence and the Constitution? All right, we know the Declaration of Independence occurred July 4th, 1776, and was a declaration that we are no longer part of Great Britain. Constitution came along 11 years later. But what's the difference between these two documents? The answer, in my opinion, the Declaration of Independence is a political document which articulates aspirational political values. The Constitution is a legal document which incorporates the political values of the Declaration of Independence into law. So we're kind of introducing the subject here. Is the Declaration of Independence says some wonderful things, but it is not law. You can't go into court and sue saying that your rights under the Declaration of Independence have been violated, because it's not law. It's a political statement. The Constitution, on the other hand, is law. It's our supreme law. And we're going to get into, well, what is law and what's the difference. But let's go back to the beginning here of the Declaration of Independence, because it says some wonderful things. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, and that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundations on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. We therefore, the representatives of the United States of America, in General Congress assembled, appealing to the supreme judge of the world for the rectitude of our intentions, do, in the name and by the authority of the good people of these colonies, solemnly publish and declare that these united colonies are, and of right ought to be, free and independent states. And for the support of this declaration, with a firm reliance on the protection of divine providence, we mutually pledge to each other our lives, our fortunes, and our sacred honor. And then with that, all of those assembled who agreed signed it. Of course, John Hancock had the largest signature. But in signing that document, they very well could have been signing their own death warrant, because such a declaration with their signature was treasonous. They were taking up and separating from the king. And of course, it could have gone badly, but we won our freedom. Interesting to note that, if I can back up here, we hold these truths to be self-evident. They weren't self-evident. The writer says they are, but he just says that. But that's how we now come to view that there's no argument to it. The phrase continues that all men are created equal. Well, it really wasn't all men when this was written. It was all white men, and frankly, all white men that owned land is what they were talking about. Poor men, African-American men, slaves, American Indians, and certainly women are not really in that phrase. They are endowed by their Creator. Now, this was, of course, drafted by Thomas Jefferson, a noted atheist, and yet he refers more than once in this declaration to the Creator or divine providence, and recognizes a higher power. But that the rights don't come from government is what he's expressing. The rights are within each of us. That's where we start. And then this phrase, life, liberty, and the pursuit of happiness. That phrase, pursuit of happiness, when we get to the Constitution, is changed. And we see in both the 5th and 14th Amendments, life, liberty, and property. Okay, pop quiz. Here is a pop quiz. Thomas Jefferson, as we know, drafted the Declaration of Independence as a member of a Continental Congress committee. Who of the persons below was not a member of this committee? 5 members were selected to be on the committee to draft this declaration. Thomas Jefferson did so, but who was not on this committee? Benjamin Franklin, Roger Sherman, John Adams, John Hancock, Robert Livingston. Those are your questions. Are they voting?
They are. It's
Okay.
always slow, the very first poll, because we take them by surprise. So
Oh, okay. All right, and the answer is, and I know these are guesses because you probably never heard of some of these folks. 25% said Benjamin Franklin was not, 31% Roger Sherman was not, John Adams, 13% was not, John Hancock, 31% said was not, Robert Livingston, 6%. Wow, you guys are good. The one who of these five who was not on the committee was John Hancock. He was president of the Continental Congress, but he was not there. And if I could go back to this group, Benjamin Franklin, Sherman, Adams, and Livingston, and then Thomas Jefferson. Originally, they went to Benjamin Franklin to draft the Declaration of Independence, and he didn't want to. He thought he was too old. So he said, no, go to someone else. So then they went to John Adams. John Adams also declined, said, no, I don't want it. Now, some authors think the reason he didn't want it is he was a little vain. He didn't want other people critiquing his writing. So he was very sensitive about that. So then they went to Thomas Jefferson. And why they went to him is he was a good writer, but Roger Sherman and Robert Livingston, who were on the committee, did not want to have a Declaration of Independence to begin with. So they were excluded simply because they weren't part of the group that ultimately drafted it. So it went to Thomas Jefferson. There were very minor changes that were made by the committee, and then the Continental Congress made very minor changes, and it became signed into law. Okay, so that was 1776, July 4th, Declaration of Independence. What role did Jefferson play in drafting the Constitution? He drafted the Declaration of Independence. What role did he play in drafting the Constitution? Answer, none at all. He wasn't in the country. He was in Paris during the Constitutional Convention. And his attitude towards the Constitution, as one historian noted, his own views on the Constitution were at best ambivalent. He was alternatively hostile, neutral, or cryptic. And that comes from Richard Paul's book, Without Precedent, Chief Justice John Marshall and His Times. Okay, now let's get into some philosophical or jurisprudential stuff. What is law? My definition is law is the coercive power of the state to enforce rules and decisions. So we have a rule that if you buy something and sell something and there's a contract, that you have to live up to your word. So we have law that says so long as the bargain was legal and followed certain legal requirements, the law will give that bargain effect. And you may go to court, and the courts, if they agree with you, will order that you get the bargain, whether that's the money that you paid and didn't get the product, or maybe get money back that you did pay. And the state's powers will enforce it. And there may be a judgment, and that judgment may attach to property of the defendants. And so we will use all the coercive powers of the state to enforce what we consider rules and decisions. And it can be rules as minor as traffic offenses to something as significant as the Constitution, which is also law. What's the purpose of law? What's the whole point of it? My opinion, again, is to establish and maintain social order, to protect life, liberty, and property, so that life is protected, liberty, your freedoms are protected, and your ability to enjoy property is protected. That someone just doesn't come in and take away your property, take away your house, take away your automobile or your life savings. What is the rule of law? We hear that expression. What does that mean? According to the definition in the dictionary, the rule of law is the restriction of the arbitrary exercise of power by subordinating it to well-defined and established laws. So in other words, we don't want arbitrary exercise of power. Might does not make right. Rather, under the rules of law, we will follow well-defined and established processes or procedures or laws that either come from ourselves, which is to say the legislatures of the states and the Congress, or in some cases from the courts, where courts have to interpret law. And so now we know the law reaches further than maybe what we had thought. So once we acknowledge that there is law, it is restricting the arbitrary exercise of power, and only law does that. Okay, so what does all this have to do with the Constitution? That's really great. But what does it have to do with our Constitution? Well, as Chief Justice John Marshall noted, Marbury versus Madison, the government of the United States has been emphatically termed a government of laws, not of men. It certainly will cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right. Now, what we're talking about here are laws of government of laws, not of men. Remember, in the monarchy, in absolute monarchies, like they certainly had in France prior to the Revolution, and to some degree in England, when the king ruled, it was what the king wanted. And whatever the king said became law. And so we did not like that way of developing law. We wanted a government of laws, which is we come together in Congress or in our legislature to determine what the laws should be. And then it applies equally to all men. And we see that expression of equality under the law in the 14th Amendment, getting a little bit ahead here, where we talk about the equal protection of the law. Judicial review, what's that? Judicial review is a phrase that uses, simply describes the power of the courts to say what the law is and to declare an act of the legislature or the executive unconstitutional. So it is the inherent power or express power of a court to tell us all what is law, and in so doing, to declare whether an act of the legislature is unconstitutional, that is, it is beyond their authority, beyond their jurisdiction, or an act of the executive that is beyond its authority and therefore unconstitutional. And if it's unconstitutional, it is void. It's meaningless. Legal trifecta. Are we gambling? No, not yet. But this is introduction into John Marshall, who is the most important Chief Justice. We'll show you why in a minute. Marbury versus Madison, the most important case, and judicial review, the most important legal doctrine. John Marshall authored Marbury versus Madison and gave us judicial review, which as a doctrine, judicial review isn't in the Constitution. We can read Article 3 any which way you like. You will not see the phrase judicial review or that in the Constitution, but it's the most important legal doctrine. All right, let's talk about this guy. Before we do, I hope some of you had a chance to look at or read the book of Without Precedent. It's a recent 2018 biography of John Marshall. I thoroughly enjoyed it, very well written. There are times when you read biographies and they really capture your imagination. I had that experience when I read a biography of the rise of Teddy Roosevelt. Confessing my own ignorance, I never quite knew why Teddy Roosevelt was on the Mount Rushmore. Lincoln's there, Jefferson's there, Washington, of course, is there. Well, they make sense. Well, why Teddy Roosevelt? How did he get in there? Well, I read the book, The Rise of Theodore Roosevelt, and found out what an amazing man Teddy Roosevelt was. A student at Harvard, where in his senior year at Harvard, he wrote an outstanding history book on the War of 1812. Why is it outstanding? Because the British government used it as a textbook in their academy, Sandhurst. So if a country says, we like that book and we're going to take it. But he was gifted in many fields, in animal sciences, ornithology, as well as the arts. And what he did before he ever became president was amazing, with the Rough Riders, the commissioner of police in New York City, the assistant secretary of Navy, and governor of New York. And then he became the youngest president ever to have the presidency at 42, when McKinley was assassinated. So I read that book and it's like, wow, that guy is amazing. Well, I had that same experience with reading this book on John Marshall. Knew John Marshall, knew that he was one of the most famous chief justices, but I really didn't realize what his personal history is. So what is it? He was born in Germantown, Virginia. His education was extremely light, just 1 year of grammar school, 6 weeks of law school. Military service, he served in the Continental Army and served with Washington at the Battle of Valley Forge. By way of backstory, John Marshall's father got to know George Washington. They were both surveyors and they worked together on surveying crews when George Washington was a young man. In 1782, he was elected to the Virginia House of Delegates and worked for the ratification of the US Constitution. And note this, authoring with James Madison, the First, Third, Fourth, Fifth, and Eighth Amendment. All of those are part of the Bill of Rights. And if you remember what I just said, it was very important that this Bill of Rights be quickly passed because the ratification of the Constitution was in doubt. And so his very work in authoring with Madison these amendments, big amendments, the First Amendment, Fourth, Fifth, Eighth, they were significant. And then he worked tirelessly to get Virginia to ratify. Virginia was on the fence. As I said, folks like Patrick Henry and James Monroe were against it. And Jefferson was ambivalent about it. And New York was seeing what was going to happen. So when he, John Marshall, helped engineer the ratification by Virginia, then New York heard that Virginia has ratified the Constitution and put pressure on New York to ratify it, and then they did too, because they frankly did not want to be left out. 1797, he was a diplomat representing the United States in France. He was a member of Congress. As a member of Congress, he served during a period when George Washington died. And it was John Marshall who was informed of that, and he took to the floor to announce to Congress that George Washington had passed. Marshall wrote a biography of George Washington and delivered a eulogy about George Washington. And in fact, he uttered that phrase that George Washington was first in war, first in peace, and first in the hearts of our countrymen. He was very close to George Washington. A little footnote here. It was obviously George Washington's stature in colonial times as the first president, as the commander of our army in the Revolutionary War. He was universally regarded and loved. Everyone looked up to the rectitude of the man. And yet, when there was a joint session of Congress that had a memorial for George Washington, the current president didn't bother to show up. And that current president was Thomas Jefferson, which I thought was very odd in that Thomas Jefferson served in George Washington's administration. He was Washington and our nation's first Secretary of State, and they were both from Virginia. They obviously knew each other, but he didn't want to go. Why didn't he go? Politics. We're going to get into the politics in the case of Marbury versus Madison, but because of political considerations, Jefferson didn't want to go to the memorial service. Then in 1801, he was Secretary of State in the Adams administration. Okay, as Chief Justice, 34 years from 1801 to 1835, he has been the longest serving Chief Justice at 34 years. He wrote 547 opinions for the court, and of these 511 were unanimous decisions. In his first 2 years, he wrote 42 unanimous decisions. And in his first 10 years, all but 13 of 227 opinions were unanimous, and he wrote at least 152. Over his 34 years, there were 1,129 decisions, and all but 7 were unanimous. And he established the doctrine of judicial review and the supremacy of the Constitution, which we'll get to in a minute. So note his contribution, how many new questions about the Constitution were presented, and they were new. And so he was writing for the court, and he wrote unanimous opinions. They all agreed. Again, for a guy who only had 6 weeks of law school. All right, what's that political climate I was referring to? Well, at the time of Marbury versus Madison, there were 2 political parties, the Federalists and what they called the Republicans, or the Democrat Republicans. The Republicans of that era bear no resemblance to the Republicans of today. They were later called Democrat Republicans and then ultimately just Democrats. But the Federalists believed in a strong federal government. Notable Federalists were George Washington, John Jay, Alexander Hamilton, John Adams, and John Marshall. Noted Republicans believed in a weaker federal government and the supremacy of the states. Those Republicans were Thomas Jefferson, James Madison, James Monroe, and Patrick Henry. The 2 parties were extremely competitive and sparked intensive political fights during elections and the appointed process. So now let's get into Marbury versus Madison, and what are the facts? Well, in the closing days of the John Adams administration, the Federalists controlled Congress, passed legislation creating new judicial positions. Adams quickly appointed Federalists to these positions, and the Senate quickly confirmed them. After the Senate confirmed the judges, their names were then forwarded to the Secretary of State, who then prepared commissions for each of the judges. President Adams would then sign the commissions. The Secretary of State would affix the Great Seal of the United States to them. Most of the commissions were then delivered to the new judges, but some commissions were not delivered before time ran out, and President Jefferson was sworn in as our 3rd president. William Marbury was one of those who didn't receive his judicial commission. President Jefferson instructed his new Secretary of State, James Madison, not to deliver the remaining signed and sealed commissions. Marbury sued Madison, demanding that he received his commission. So remember the elections in November, but at this time in history, the president doesn't take office until March. So following the election, Adams was going out, but there was from November to March. Jefferson was coming in. They were political loggerheads of 2 separate parties, think Republicans and Democrats today. And the Congress created these new judgeships. And so Adams was trying to flood the zone and put as many of his loyal Federalists on the bench. And of course, when Jefferson finally took over, he said, stop it. So the question is, does Marbury have a right to receive his commission? He was nominated by the president, confirmed by the Senate. The president signed his commission. It had the seal affixed. He just didn't get it. But does he have a right to receive it? Can he sue in court to get his commission? And does the Supreme Court have the authority to order the Secretary of State to deliver the commission to Marbury? Those are the issues that the Supreme Court had to address. The court held that once the commission was signed by the president, he had no right to deny Marbury's commission or remove him from office. The right to the commission vested. That means it's a completed act when the president signed it. The delivery, the fact that it wasn't physically delivered, didn't matter. And Marbury, yes, can sue in court, because here we get this expression from John Marshall. The government of the United States has been emphatically termed a government of laws and not of men. It will certainly cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right. So he was kind of poking Jefferson by saying this is a government of laws. And under the law, Marbury was nominated by the president, confirmed by the Senate, the president signed his commission. That's all the law requires. And it's not of men, Jefferson, so you can't now overrule that law, because we would cease to be a government of laws and one of men. But the third issue is no. This is the twist. While the Supreme Court has authority over the President and the Secretary of State to require them to perform non-discretionary acts the law requires, in other words, things that the law insists that they do, the court could not issue what's called the writ of mandamus. That is the order from the court telling the Secretary of State to do something. Why? Now it gets a little technical. Because the Judiciary Act of 1789, which expressly gave the Supreme Court the power to issue such writs, violated Article 3 of the Constitution. Wait, what? Congress could not expand the powers of the court beyond the Constitution. And the writs of mandamus were proper only in specific cases involving ambassadors, public ministers, and the states. And this is not such a case. So Marbury sued in the Supreme Court in what's called original jurisdiction, seeking this mandamus because the Judiciary Act, an act of Congress, gave him that right. And what Marshall is saying, they didn't have that right under the Constitution. Congress did not have the power under the Judiciary Act of 1789 to give the Supreme Court more authority than what the Constitution gave. So the Act of 1789 is unconstitutional and is void. Significance of the holding. First, this is the first case to hold that an act of Congress was unconstitutional. By the way, the next time the court did that was 54 years later in Dred Scott, finding slaves were property and invalidating the Missouri Compromise. Second, the court had jurisdiction over executive officials. Now, this seems obvious now, but it wasn't then. When the trial was going on, Marbury's lawyer couldn't get anyone for the defense, the Secretary of State Madison, to show up. Madison did not appear at the trial, nor did any attorney appear for the Secretary of State at trial, because Mr. Jefferson felt that the Supreme Court didn't have jurisdiction over executive officials. Remember, they're all three separate, co-equal branches of government. So who are you, Mr. Marshall, to tell me, the president, what I can do? I don't think you have jurisdiction. So both Madison, the Secretary of State, and the President Jefferson did not believe the Supreme Court could do anything. Third significance, the Constitution was a higher form of law than both the executive and the Congress must act consistent with it. Now, what are we talking about there? Let's go back to that Declaration of Independence. And that's why I made the point that that is a political statement of aspirational values, okay? But Marbury versus Madden tells us now that the Constitution is something different. It is law, and it's a higher form of law that both the executive and the legislature, the Congress, must adhere to. And who gets to decide that? Well, that is the Supreme Court. As he writes, there are three co-equal branches. It is up to the Supreme Court to decide the meaning of the Constitution because, quote, it is emphatically the province and duty of the judicial departments to say what the law is. So yes, all three are co-equal, but in terms of interpreting the law, in terms of interpreting the Constitution, the Supreme Court is supreme and can strike down these acts because that is the implied duty, not really expressed in the Constitution, of the judicial department to say what the law is. All right, backstory, and this is big. As I said, the case was filed and tried in the Supreme Court. The trial lasted 4 days. Secretary of State Madison did not appear, nor did any lawyer appear for him. Madison and Jefferson believed the court had no jurisdiction over them. Jefferson would have refused to honor a writ of mandamus had one issued. So if Marshall had issued the writ and ordered Madison to deliver it to him, they would have ignored it. And the court, through Justice Marshall, would have had no ways to enforce it. And although everyone, quote, knew that Marbury was nominated by the president and confirmed, he still had to prove that fact in court. So Madison, because he did not appear, and other officials at the trial conveniently couldn't remember or refused to answer whether Madison's commission was properly signed, there was one person who absolutely knew that the commission was properly signed, sealed, but not delivered, and that was Chief Justice Marshall himself, who had been the Secretary of State when this all went on. So literally, Madison's commission was on the Secretary of State's desk, and that Secretary of State was John Marshall before he was Chief Justice, and Marshall knew that it had not been delivered. But now he's the judge presiding at this trial. It is highly inappropriate for a judge to preside over a trial where the judge could be a witness and could testify. It didn't slow down Justice Marshall. In order to prove that critical fact, Marshall's brother, who worked for Marshall when he was Secretary of State, James, submitted an affidavit indicating that he was responsible for delivering the commissions and he was unable to deliver Marbury's. According to Marshall's biographer, again, this Joel Richard Paul, it is very likely that the affidavit is false and that Marshall knew that. Paul also argues that it is likely that Marshall procured the false affidavit and contrived with Marbury's lawyer to have the case filed in the wrong court to begin with, simply to allow Marshall to develop the doctrine of judicial review without having a direct conflict with the president. So he was able to get this case that would work out perfectly, where he could announce judicial review and that the Supreme Court is, but then at the end say, well, but I'm not going to order the president to do anything. So there was nothing for Jefferson or Madison to object to. The court declared the executive and Congress must act consistent with the Constitution, and the court will determine what the Constitution says and means. And by declaring that act of 1789, no writ would issue to be ignored. So here's a pop quiz. That's judicial review. Amazing story. Get into the details of the case, but that's the principle. Is judicial review necessary to protect our constitutional freedoms? Yes, no, and here's one to save you. I don't know. So be honest, tell me what you think.
Okay, so ignore the fourth answer, which is 3. I think that was from last week. Unless you don't know, you might choose 3.
Yes, 69%, no, 19%. I don't know, 13%. And 3 didn't get any votes. Good for you guys. All right, is judicial review necessary to protect our constitutional freedoms? I'm going to go with I don't know. Here's what I call comparative judicial review. In Great Britain, there is no judicial review. Great Britain has no written constitution. Acts of Parliament are the supreme law of the land. And by definition, Parliament thus cannot act unconstitutionally, because an act of Parliament is the act of the people. In Canada, they have judicial review, but they specifically granted that to their Supreme Court in their written constitution. Their constitution provides the Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. As we said, in the United States, judicial review was created by Marbury versus Madison. It's not specifically in the Constitution. So is it a power grab by Marshall or a necessary decision? All right, let's talk about some other legal concepts quickly. Procedural law, which is the process, versus substantive law, the merits. When we talk about procedure, we're talking about how the court decides a case, the process. When we talk about substantive law, is what the court decides. Standing. What does that mean? Doesn't mean getting up from a seated position. Standing means you have the right to bring a lawsuit. Not everyone can bring a lawsuit. If somebody does something to my property, I can file a lawsuit against who I thought did something to my property. But I can't bring a lawsuit because somebody might have done something to my neighbor's property. I don't have standing to bring that lawsuit. Judiciability. That simply means, is the issue capable of being adjudicated? Not everything is a legal issue. Some are political issues. Some are just issues that are not susceptible to a court ruling, so they're not judiciable. Jurisdiction. Who or what has the authority to decide the issue? Personal rights for collective rights. Personal rights are, by nature, yours. You own them. They are personally with you. They're part of your inalienable rights. But we also have in the Constitution collective rights. That's where we're talking about the rights of the group or the many. And mootness. What that means is if an issue is moot, it means the issue no longer exists. It was a big issue, but it's been addressed or it has evaporated. So there's really nothing for the court to decide. All right, here is this case, and I should have thrown this up as a pop quiz to have you guys figure out how to pronounce the plaintiff's name and maybe how to pronounce the defendant's name. I can't pronounce either, but this was an issue that, an opinion that came down this year, and I'm just gonna call it U versus P. And here are the facts, and we're gonna talk a little bit about standing and mootness. The petitioners are former students of Georgia's Gwinnett College who wish to exercise their religion by sharing their faith on campus while enrolled there. In 2016, GKU walked with interested students and handed out religious literature on campus grounds. U stopped after a campus police officer informed him that campus policy prohibited distributing written religious materials outside areas designated for that purpose. A college official later explained to U that he could speak about his religion or distribute materials only in 2 designated speech areas, excuse me, on campus, and then only after securing a permit. But when you obtained the required permit and tried to speak in a free speech zone, a campus police officer again asked him to stop, this time saying that people had complained about his speech. Campus policy at the time prohibited using the free speech zone to say anything that, quote, disturbs the peace and or comfort of persons, close quote. The officer told you that his speech violated that policy because it had led to complaints, and the officer threatened you with disciplinary action if he continued. You again complied with the order to stop speaking. Another student who shares U's faith, Joseph Bradford, decided not to speak about religion because of these events. Both U and Bradford sued certain college officials charged with enforcement of the college's speech policies, arguing that these policies violated the First Amendment. As relevant here, the students sought injunctive relief and nominal damages. Injunctive relief is when you're asking the court to issue an order directed at an official for them to do something. Usually don't do something. Nominal damages is when you don't have actual damages and they are awarded like $1 or sometimes $10. So what are actual damages? Actual damages is you can actually prove that you lost something as a result of this policy. So if he had lost a job and lost income, he might be able to claim that as actual damages. But since he complied, he really couldn't point to anything specifically that would constitute actual damages. But nonetheless, if he won, his rights would have been violated. And so he would be entitled to nominal damages, like $1. Okay, you're right. Now, frankly, in litigation such as this, if you are, quote, the prevailing party, it means if you win, and if you win $1, something is going to immediately trigger because you're the prevailing party. And you know what that is? Attorney's fees. So all the attorney's fees that you expended to win that $1, you get back and you are made whole. You get your $1, when your attorney gets the attorney's fees. So a lot of times there are tens of thousands or more at issue because of damages, nominal damages. Okay, the college officials ultimately chose to discontinue the challenge policies rather than defend them. They knew they were going to lose. So they said, we got to back off of this bad policy. They sought dismissal in federal court on the ground that the policy change left the students without standing to sue. The parties agreed that the policy change rendered the students' request for injunctive relief moot. There was no point in the court issuing an order. Why? Because they agreed voluntarily not to enforce it. So that's moot, it's gone. But they disputed whether the students had standing to maintain the suit based on the remaining claim for nominal damages, that $1 award. What did the Supreme Court rule? They held that a request for nominal damages satisfies the element necessary for Article 3 standing, where a plaintiff's claim is based on a completed violation of a legal right. So they could show that they had been violated, and late in the game, the university backed off, but their rights had been violated, so they couldn't show actual damages, and there was no need for injunctive relief. We want our buck. That's what the Supreme Court says. Yep, that's okay. But now here's Justice Thomas delivering the opinion for the court. At all stages of litigation, a plaintiff must maintain a personal interest in the dispute. The doctrine of standing generally assesses whether that interest exists at the outset, while the doctrine of mootness considers whether it exists throughout the proceedings. To demonstrate standing, the plaintiff must not only establish an injury that is fairly traceable to the challenged conduct, but must also seek a remedy that redresses that injury. And if in the course of litigation, a court finds that it can no longer provide a plaintiff with any effectual relief, the case is generally moot. This case asks whether an award of nominal damages by itself can redress a past injury. We hold that it can. But the Chief Justice dissented, and this is remarkable because he doesn't dissent a lot. And he writes, petitioners Chike Yu and Joseph Bradford want to challenge the constitutionality of speech restrictions at Georgia Gwinnett College. There are just a few problems. Yu and Bradford are no longer students at the college. The challenge restrictions no longer exist, and the petitioners have not alleged actual damages. The case is therefore moot because a federal court cannot grant Yu and Bradford, quote, any effectual relief whatever. The court resists this conclusion, holding that the petitioners can keep pressing their claims because they have asked for nominal damages. In the court's view, nominal damages can save a case from mootness because any amount of money, no matter how trivial, can redress a past injury. But an award of nominal damages does not alleviate the harm suffered by a plaintiff and is not intended to. If nominal damages can preserve a live controversy, then federal courts will be required to give advisory opinions whenever a plaintiff tacks on a request for $1, because I would place a higher value on Article 3. I respectfully dissent. So what the Chief Justice is worried about is, oh my gosh, are you serious? How many cases are going to be running into federal court, even when there are no actual damages? Nobody has suffered anything you can prove. But we want that nominal damages. We want that buck. There'll be all kinds of cases. And he says he would place a higher value on federal court jurisdiction, Article 3, and would not allow the case to go forward. Okay, stare decisis. Now we're getting into foreign languages. It's Latin. What is stare decisis? Stare decisis, the best definition of the Latin, is simply let the decision stand. You can kind of see stare, stand, and decisis, decision, so it's kind of in there. This is the legal doctrine that requires courts to follow the precedents of earlier court decisions, particularly those of higher courts which have addressed the same issue. Stare decisis is a balance between stability and predictability of law, with flexibility and the ability to change the circumstances required. So on one hand of the scale, we want stability. We don't want the law to be changing all the time. The law is always changing. We don't know what it is. We want to be able to order our lives with predictability that this is what the law is. I'm pretty sure about it. So stability and predictability of law is important. But on the other hand, we need flexibility and we need to be able to change as circumstances require. So that's the balance that goes on. Pop quiz. Which branch of government is least concerned about stare decisis? Which branch of government is least concerned about stare decisis? The legislature, the executive, the judiciary. All right, how did we do? Which branch is least concerned? The legislature. Well, we have a tie, 46 and 46. 46% say the legislature, 46% say the executive, and 8% say the judiciary. All right, let's see what the answer is. The answer is the legislative. No Congress can bind a future Congress. In other words, no Congress can answer all of the problems today and say, this is it forever and ever. We don't need to come back anymore. Every new Congress, every 2 years, a new Congress can do things. Now, they may be bound by it to a degree, but we want flexibility with it. So on that stability, predictability scale on one side, and the flexibility, changeability, if you will, on the right side, courts, because we're dealing with law, should be the most stable and the most predictable. The Congress, since we're dealing with mostly political issues, should be the most flexible, so it can change with whatever the mood of the people is. And the president, the executive, is somewhere in between. Yes, the president is political, no question about that. But the president also is legal. Legal in this, we've seen it so frequently in the last 2 years, where the president issues executive orders. Now, there's a problem with the president X issuing an executive order. President Y comes in and changes the previous president's executive order, and President Z comes in and changes it back or again. That there is that flexibility, they can do it, but because they're dealing with legal issues, we should have something a little bit more substantive, something a little bit more stable. Give you current examples. President Obama engaged into a executive action with Iran, an executive agreement with Iran. It wasn't a treaty. It wasn't presented as a treaty. It wasn't confirmed by the Senate. So it did not become the supreme law of the land the way a treaty would. It was just an executive agreement. And when President Trump came in, he didn't like the agreement, so he walked away with it. President Obama did the same thing with the Paris Paris Climate Accords. President Trump comes in, he walks away from it. Now President Biden comes in and wants to redo the Iranian agreement, and he has re-engaged in the Paris climate, and the XL pipeline is another case where we're going to build it. No, we're not. Yes, we are. No, we're not. So the president is somewhere in the middle in terms of stability, predictability, and flexibility and change. But clearly the courts, it's very important. And for the Congress, it's least important. All right, let's talk about Franchise Tax Board versus Hyatt. Now, this is a case of a couple years ago, but it illustrates stare decisis and gives an example of that. Hyatt, a Nevada citizen, sued the California Franchise Tax Board in a Nevada state court. California argued that it was immune from the suit under the doctrine of sovereign immunity, as it had not given permission to be sued. So a Nevada citizen sues California in Nevada. And California says you can't do that. The issue is whether the Constitution permits a state to be sued by a private party without its consent in the courts of a different state. You can sue your state in your state courts, but can you go sue another state in your courts? A little bit different. Supreme Court in this case held, we hold that it does not, and overrule our decision contrary to Nevada versus Hall. So Nevada versus Hall was the prior decision that they are overruling. And that's what we're going to talk about, stare decisis. Justice Breyer dissented. He wrote, can a private citizen sue one state in the courts of another? Normally, the answer to this question is no, because the state where the suit is brought will choose to grant the sister state immunity. But the question here is whether the federal constitution requires each state to grant its sister states immunity, or whether the Constitution instead permits a state to grant or deny its sister state immunity as it chooses. We answered that question 40 years ago in Nevada versus Hall. The court in Hall held that the Constitution took the permissive approach, leaving it up to each state to decide whether to grant or deny its sister states sovereign immunity. Today, the majority takes the contrary approach, the absolute approach, and overrules Hall. I can find no good reason to overrule Hall, however, and I consequently dissent. The majority believes that Hall was wrongly decided, but an argument that we got something wrong, even a good argument to that effect, cannot by itself justify scrapping settled precedent. I understand that judges, including justices of this court, may decide cases wrongly. I also understand that later appointed judges may come to believe that the earlier appointed judges made just such an error. And I understand that because opportunities to correct old errors are rare, judges may be tempted to seize every opportunity to overrule cases they believe to have been wrongly decided. But the law can retain the necessary stability only if this court resists that temptation, overruling prior precedent only when the circumstances demand it. Why is this something big? Well, there is concern that due to the composition of the court, some cases now will be more susceptible to being reversed. We've got one of the cases that's currently up there now dealing with the Affordable Care Act or Obamacare, where because when that first was decided, Justice Kennedy was on the court, Justice Ginsburg was on the court, and now because there's a different composition and Scalia was on the court, perhaps that might be a different outcome. The court initially said the case was constitutional. Maybe now they will say no, but that case a couple of years ago was wrongly decided. We're going to set it, we're going to reverse it. The most politically charged one, of course, is Roe v. Wade. Roe v. Wade's been around since 1973. And now there may be a majority on the court that says that case was wrongly decided. It was a mistake and it needs to be changed. Or will they be standing on principle of stare decisis, that we're not going to just change it because we have a different view. We have to be dedicated to the legal proposition that we need to give stability to the law and we're not going to change it. But stare decisis doesn't mean you have to adhere to precedent all the time. If that were the case, we wouldn't have had Brown versus the Board of Education, because Brown versus the Board of Education in 1954 overruled Plessy versus Ferguson. Plessy versus Ferguson said that separate but equal was okay. And the Supreme Court in Brown versus the Board of Education said, no, it is not okay. We're reversing that decision. So cases come down, they can be very challenging, politically motivated cases. And the question becomes to the court is, are we going to stand on legal principle and something like stare decisis, or is this the type of cases, Justice Breyer, that we overrule prior precedent only when the circumstances demand it? Okay, we've talked a lot tonight about law. We've talked a lot about legal concepts like judicial review, issues of stare decisis, mootness, standing, We got into Marbury versus Madison to see how cases come about. I wanted to follow up on Marbury versus Madison because the court held in Marbury versus Madison that he was entitled to his commission, but they couldn't issue the writ. So my question was, well, did he ever get his commission? What happened to Mr. Marbury? Did he ever become a judge? And the research that I was able to uncover is unclear. I don't think he ever became a judge. And more sinisterly, it may have all been a contrived case, and he didn't want to be a judge to begin with. They were just looking for this issue, the Federalists, so that John Marshall could announce this legal doctrine of judicial review and set the Supreme Court up to rule. Now, why would they want to do that? My guess, just a pure guess, is again, Marshall was a Federalist and Jefferson was not. And there was such political rancor between the two that I think they were looking to have a check on this executive so that if he does something that is unconstitutional, now the Supreme Court through John Marshall can declare it so and serve as the umpire, if you will, on what is right and what is wrong. Fascinating case, a lot of history to it. I would commend you again the book Without Precedent because it goes into much more detail, but it's very interesting. Okay, thank you. Next week, we're going to jump into the next area, the Civil War, the 14th Amendment. We'll talk about due process and equal protection and how the Civil War shaped our view of freedom and equality and strengthened our federal government. We are going to hear in what we discuss next week some of the echoes of the Declaration of Independence, as well as talk about the Constitution. So hope to see you next week. Before we go, any questions, any comments that you may have?
And there's just one more question. I think you addressed it. Are the attorney fees taxable to the prevailing party?
Yes. Normally, in most cases, we have what's called, I forget the name of it right now, but it's where each party bears their own costs. There are specific statutes that flip that around. And civil rights statutes are one. Title VII that deals with employment cases is one such. So there, Congress has specifically said that if you win an employment discrimination case, or if you win a civil rights case and are the quote prevailing party, you then can recover the attorney's fees that you expended to vindicate your legal right. But unless there's a specific grant by Congress of that, the standard view is each party bears their own. So in that case, dealing with the First Amendment, that would be a civil rights case. It would be brought under what's called 1983 action. That's Section 1983. And so that $1 that Mr. Yu would get, his attorneys might get, well, probably hundreds of thousands of dollars because it went all the way to the Supreme Court. And the university would have to pay it.
Okay, and I don't see any other questions.
All right. Well, be that as it may, it's still beautiful weather, so let's take advantage of it. Hope you enjoyed tonight. We talked about these things. Next week, we get into the 14th Amendment and some Civil War, and I hope to see you then again. Thank you all.
Judge, another enjoyable 90 minutes. Thank you.